Call to order the meeting for the Dickinson City Commission, Tuesday, August 23rd, 2016. Let it show that all commissioners are present and that we are meeting to talk about the East Water Tank changes. And is there any changes to the order of business?
No, there is not, President Decker. At a special meeting, we can't change the order.
Okay. All right. Who's going to cover the memo part?
Certainly the first item, Engineer Kubis.
Okay.
Thank you, President Decker, Commissioners. First agenda item is the East Water Tank change order. Should be change orders plural, and the KLJ settlement agreement. As was discussed at the August 1st meeting, the preferred solution for the East Water Tank was to lower the tank. And so change order 2 is really the document that outlines the costs involved with lowering that tank to the correct elevation. Change order 3 is actually a deduct to the contract amount because the painting hasn't been started yet. There was a reduction in cost to paint a lower tank and a smaller tank. So those two change orders really constitute what we agreed as the preferred resolution to the East Water Tank issue. The third component of this is really a settlement agreement. As it was discussed at August 1st meeting, KLJ will be covering the costs for the change order number 2, the cost to lower that tank. And so those terms are outlined in the settlement agreement. The other amount in that settlement agreement is the difference between what we paid, what was bid out for the higher tank, and what would have been the cost to initially construct this shorter tank. And so how we came upon that number was through some conversations and coordination with KLJ and with McGuire Iron, the contractor. We'd gotten 3 quotes of what the estimated cost would have been to construct the lower tank. And taking an average of those 3, that amount will be reimbursed to the city. That's important because we're also being reimbursed for a portion of this project through the State Water Commission. So we in turn need to turn in appropriate invoices to the State Water Commission. There's also time in the field spent by our engineer that would not have been needed to be spent inspecting the construction of the stem of that tank, inspecting the welds on that tank. So a portion of that settlement agreement is the engineering fees as well. If we could move to the next slide, I guess talked about that the settlement agreement includes an average of the 3 quotes, one of those quotes being our contractor's quote. What we had questions on was, were there any substantial differences in how this tank would have needed to be constructed? And our contractor made myself very comfortable anyway, saying no, their means and methods to construct a tank at either elevation is almost identical. It's the same crew, it was the same cranes. The tank that they ultimately needed to lift was the same, the bowl section is the same size on both tanks. So their means and methods of construction were very similar. We even talked about things like, well, the foundation of this tank. And you can see on the slide that water, when the tank is full, really accounts for over 80% of the weight of the tank. So the foundation really would remain unchanged or a negligible difference. It could have been slightly smaller if this tank would have been, the foundation were designed for a shorter tank. So they based this on a lot of bid history. They've won 35 projects for 35 tanks this year, have bid on many, many more. And so they felt very comfortable with their numbers because they bid tanks this tall and bid much shorter tanks too. So they have a pretty good bid history on these things. And again, like I mentioned, the settlement agreement also includes a reduction in engineering fees for mostly time spent in the field that otherwise wouldn't have needed to been spent. So that really covers the two change orders and the settlement agreement. Our completion date for this, since our contractor's been on hold for quite a while now, and they'll have some additional work to do, we've extended the completion date really towards the end of the year, even into January. Again, the contract completion date and all the terms of the contract will remain in effect. If they have to finish this tank later in the spring next year, liquidated damages could be charged again, but this will give them what we feel ample time to lower the tank and give them time back on the contract for the time that they've been unable to work on the tank the last month or so. So with that, I know we have representatives from KLJ here to answer any questions you might have, or any questions you might have for myself. I'd be happy to answer them now.
Does anyone on the commission have any questions for either Mr. Kubis or any KLJ representative?
I do have a couple questions, Mr. President. What would the final cost be on the on the tank that we're supposed to get?
Excuse me, Commissioner Steiner, are you talking about the revised tank or the existing?
If we had received the correct tank right away, what was that estimated cost?
We asked that very question. I was concerned during the negotiation phase, I'll call this, that we weren't asking the right question right away. And my question was, let's not talk about lowering the tank. Let's talk about what it would have cost us to engineer and create a tank originally that was of the right size. And that is the exact question and that was asked of the firm that's building it, McGuire Iron. They confirmed that in a conference call, so we had a representative from McGuire Iron, and that's the exact question that KLJ asked that staff member. So what they put forth as a settlement offer, that original, was what they thought it would take to do exactly that.
But what was that number?
Oh, it
I mean,
was,
there's two numbers I want to know. The number of what it costs for the original tank if we would have received it. And two, the final number of what it would cost for the tank that's there now if it was the correct tank.
Commissioner Steiner, the bid, and I don't have the, I do, it's actually in the change order that you have in your packet. The original agreement amount should be in that change order number 2. Towards the bottom of the page, it was 1.56 million was the original bid. That's what we were set out. We have a contract with McGuire Iron to build a $1.56 million tank.
Is that the one that's currently sitting there now?
That's the one that's sitting there now.
Okay.
The difference, the reduction in cost is about $139,000, $138,900. So on a percentage basis, I guess I didn't punch that in, probably 8% or so reduction.
So that 78 feet or whatever it is, they're saying was an additional 139,000
Correct.
cost.
Correct.
Okay, so the one that's out there now, I'm getting kind of confused where we got the original contract amount, $1,568,000, with a decrease of $10,000. Then you got a contract amount prior to this change, $1,558,000, and then we got an increase of $506,100. What's the $506,000?
That is the cost to lower the tank. And the reason that we're running this through a change order and it's showing up as an increase to the city is because we want all the assurances and the insurances that we have of McGuire Iron right now to run through this contract. We really didn't want a side deal with between McGuire Iron and a third party. So our agreement stays in effect. This agreement adds to their contract. It's going to be another $500,000 to lower the tank. The settlement agreement then between the city and KLJ states that KLJ will directly pay that amount
At 500?
to lower the tank.
Okay, so that explains why we're adding it to the the 506,000
We're-
to the 1,000,005.
Correct. We're adding it so everything's still running through our contract. The warranties and the insurance that we have on the contract still apply to this work that's being done. The settlement agreement then, on the side, says it'll be paid by KLJ.
Okay, so that's one set of numbers. So what you're saying is 139,000 is the total, what we're going to get reimbursed between the two tanks.
Correct.
That's it,
That will,
139,000.
that number covers what would have been the additional work to construct and design the tank, inspect the tank, that we didn't need to do. We shouldn't have had to
Right.
do. And so that'll be a direct reimbursement to the city.
Okay, thank you.
Mr. President, I have a couple of questions.
Go ahead, Mr. LaFour.
So, expanding on what Commissioner Steiner said, it would have cost 1.5, but now it's going to cost the 1.5 minus the 139, is that what you're saying?
Correct.
Okay. And then, and I talked to Sean about this a little bit, but by signing a release, we're not limiting ourselves in any way from anything in the future as far as unforeseen circumstances.
That's correct. And that's why we really wanted the $500,000 addition to run through the contract. So our warranty on the tank, these, there'll be new welds that need to be in place. All those, everything that they're going to do to deliver us the ultimate finished product of the lower tank will have all the same guarantees, warranties, and insurances that the original contract had.
Okay, so you're comfortable that if we sign this release, we're still going to be okay from us changing the water tower from what it is to what it should be, what it should have been, correct?
I believe we are. I don't know if Ms. Kripe wants to chime in on that. We had some discussion on that release of liability or limitation of liability as well. So.
Commissioner LaFour, members of the commission, the settlement agreement is limited to the scope of the error regarding the height of the tank. But if there was some other workmanship error that would come up that we'd find out within the warranty period, that would not be voided by this. So the settlement agreement is limited only to the fact that the city can't go back to KLJ regarding any other claims as to the damages incurred by the height of the tank. And that this settlement agreement is intended to cover every damage that was foreseen and unforeseen regarding the height only.
Do you have any concerns about this release?
I've reviewed it. I've spoken to KLJ's counsel as well as Mr. Kubis and Mr. Kessel, and I think we've reviewed and discussed all the possible weaknesses and limited the city's exposure in the most appropriate way. So I'm comfortable with the settlement agreement.
Thank you.
Any other questions by commissioners for Mr. Kubis, or there's two representatives here from KLJ, so. I read through the agreement and I had kind of the same concerns Mr. LaFour did, future damages, I guess, and that's explained pretty well there about this basically just covers the height issue, so. Okay, well, if we have no further questions, we'll take a vote on approving or disapproving this agreement.
Mr. President, I would move we approve the settlement agreement and release.
We have a motion to approve,
Second.
and we have a second. Any further discussion? Hearing none, we'll take a vote. Mr. Steiner?
Aye.
Mr. Altman?
Aye.
Ms. Jennings?
Aye.
Mr. LaFour?
Aye.
Chair votes aye. Motion passes. All right, we have another item on the agenda here, the urban boundary.
President Decker?
Oh, I have that on mine, so.
I'm not sure if it's appropriate or if it's necessary, but I think we might need a motion to approve or disapprove change order number 2. It's all kind of covered in the settlement agreement, but with the dollar amount, I think it would be
Okay.
appropriate to make a separate motion.
All right, we need a motion to either approve or disapprove the adjustment on change order 2.
Mr. President, move to approve.
We have a motion to approve,
Second.
and we have a second. Any other discussion on this?
Do we need to do that on number 3 also, or just number 2?
Change order number 3, as it's a deduct, I think we could approve that at staff level, actually. so.
All right.
Yeah, we,
Okay, any other questions? Hearing none, we'll take a vote. Ms. Jennings?
Aye.
Mr. Altman?
aye.
Mr. Steiner?
Aye.
Mr. LaFour?
Aye.
Chair votes aye. Approve change order number 2. And you're going to approve the change order number 3 with the deduct at staff level.
The previous commissions have given staff the ability to approve change orders that are a certain percentage above the existing contract, so this would obviously fall within that since it's a deduct.
Okay. Does anybody on the commission have any problems with that? Let staff approve this? All right. Urban area boundaries, resolution?
Yep. President Decker, I believe that was maybe an unintentional carryover
Okay.
from the previous meeting last Monday.
All right,
so.
I got it stuck in here, so.
Yeah, I did too.
That's why I was surprised when I saw that.
Okay. And then we have one other item on here, a report, or is that
Yes,
actual? or is
that's an
that-
actual
Okay,
item,
that's
yes.
actual, all right.
Sorry about the confusion, President. This item, I'm only going to introduce it, then I'm going to turn it over to Ms. Kripe to give you a more thorough introduction. But this results from the continuing issue of Ms. Jennifer Goss's release from employ as our city attorney. We had a confusion when the Civil Service Commission started to review this item. They took it under advisement after our original hearing, and it was noticed that there are conflicting data within our ordinance and with the job description. So the job description states that the city attorney is a civil service eligible position. So it has all the rights to civil service benefits. Our ordinance says it is not. It specifically excludes the city attorney from the Civil Service Commission. In fact, I'm also excluded from the Civil Service Commission process. So to make sure that they had proper advice, I hired the firm of Pearson Durek from Bismarck to give us some thoughts. And the decision that they arrived at was that the ordinance takes precedent over the job description. Now, there was no state trial that provided precedent, and there was no 7th District trial of which we reside that provided precedent. So she had to go to the 8th District in order to find some precedent that was similar in nature to this. But that was her opinion, is that the ordinance takes precedence over a job description. So in that scenario, that means that Ms. Goss is not covered by civil service and should not have had a hearing in front of that board. So she doesn't have appellant rights in that order. Her appellant rights actually go to district court. So the Civil Service Commission is essentially done with this item, but Ms. Goss may come to you as a city commission to ask you for your thoughts on whether or not the attorney we hired was accurate in her interpretation of the job description versus this ordinance. So that's where we're at today. In terms of the city of Dickinson, this issue is resolved unless Ms. Goss brings it to you and asks for your thoughts, and then your consideration would be on that item alone of whether or not civil service has jurisdiction in this arena. So you can say either yes or no. If you say no, they do not, then the district court is her option. If you say yes, then the civil service will go back and make a decision, and then depending upon the result, you may have to render another decision if it's appealed to you. So having said that, Ms. Kripe, did I get it right? Is that pretty accurate?
That is correct. The only minor discrepancy was the circuits.
Oh,
So
sorry.
we're in the 8th Circuit Court of
Okay.
Appeals, and the case that Ms. Kaufman found was in the 7th Circuit Court of Appeals. Without getting into a larger civics lesson, in the strain of court precedents, we would go to the 8th Circuit for our guidance. Absent any guidance there, we look to other circuits to see what the guidance is. If there's multiple circuits, we call it a circuit split, if they've come up with different opinions among them. And then those are typically the cases that go to the Supreme Court. As you might imagine, this is not a very common issue. So if you ask for court cases on motions to suppress, a breathalyzer test, we could find you hundreds of thousands of cases. Whether or not a job description or civil code has precedent is a kind of a niche issue, and the case law is fairly limited from my understanding. And so I did, at the request of Mr. Kessel, forward you that letter from Rachel Berner Kaufman, who's the attorney that rendered the opinion for the Civil Service Commission. So you have that. If you'd like, I can pull the full case for you so you can read it. If anyone's interested, I'm happy to do that.
Now, if she comes before us and we say, well, civil service needs to handle this, wouldn't the ordinance still take precedence? Isn't that what you just stated? Or are we voiding that?
You would essentially be settling the issue of the conflict, because the ordinance, as it states, says she doesn't have appellant rights. So
Right.
she never should have had the civil service hearing. Hence, there is no appeal to the city commission. It would have went to district court if she chose to
Right.
take it on. So, like I stated, in our thought process, this issue is over because we've obtained an opinion that says that she doesn't have appellant rights to the civil service, but she may ask you to make that determination yourself. And if you choose to allow her civil service rights, you could, which would mean the Civil Service Commission would have to render a decision then on the hearing that they held.
And the ordinance was updated to reflect, probably when Matt Colling came on, we had made changes because before that we had had a contract for city attorney. Matt was the first employed city attorney, so that's when the ordinance was updated to reflect that it's an ordinance rather than a civil service.
Commissioner Oltmans, that makes entire logical sense. I don't have it in front of me, so I can't tell you when it was updated, but that absolutely makes sense.
I guess my question is, the ordinance was updated to reflect that position.
Commissioner Oltmans, member of the commission, my understanding from looking back at the case, the code and the notes on the revisions, as well as some city commission meeting minutes, is that even when Mr. Colling was the in-house city attorney, he was based on a contract. And then when he left his position, it was determined that there would be the option, is what the minutes look to reflect, of whether or not, it's vague, I guess, unfortunately, that the new person could choose to be civil service or could be left out of the process, and that, so the code was not changed. And then the only thing that was done was that the job description was edited to include that it could be civil service. But at the time that that job description was approved, there was no code change. And so that's where we're getting this discrepancy. So the code was changed. There was a consideration of the code at the time Matt left, but there was no change.
Okay, so then when Ms. Goss was hired, she hired under ordinance, or was she hired under the other?
There's no way, that's not a topic that comes up in the hiring process,
Right.
as if they're civil service or not.
Right?
So there's really no guidance from the hiring process. From a job description process, we do provide the job descriptions as part of your hiring process. She was provided that. But obviously, as a city attorney, she works intimately with the ordinances. So hence why we got the opinion, because it is confusing.
Well, I guess this is all subjective unless she
Right.
comes before us, so.
Right.
I guess we'll have to deal with if she's before us in our future commission meetings.
I agree. But in the future, I would expect the wording in the job description will then be changed to reflect the ordinance, or the
That-
other way around.
We'll
So
make
they're
sure
one.
they are in harmony. That's exactly right, Commissioner LaFour. And we are working on the HR upgrades, manual upgrades. Hope to have those before you, maybe your second meeting in September.
Ms. Kripe, I would like the case information if she does come before us, so that we can read through it, have that information.
I would too.
Okay, that's not a problem. I'll go ahead and pull that case and just email it to all of you now, and then, or in the very near future. And then you'll have it just for your own information. They tend to be a little bit lengthy, so it's not something you want to try and skim in a hurry if that does become an issue before you. So that'll give you time to look it over.
Great, thank you.
And then I guess another question would be if she is before us, because Ms. Kripe tried that case, do we need other legal counsel for that issue?
That is an issue that was brought forward by Ms. Goss during the Civil Service Commission, suggesting that Ms. Kripe has a conflict of interest by arguing it because of her employment as the interim city attorney, or her firm as the interim city attorney. So I think that is something we'll have to consider as we move forward, if we move forward.
Mr. President, members of the commission, it is an awkward juxtaposition in this particular situation because typically the code provides for the city attorney to represent the city through the civil service process, but in this one unique position, it is awkward that the city attorney is arguing regarding the city attorney position.
Right.
And so if you'd prefer to have other counsel, I will not be offended at all. So that's entirely your option.
Okay. And I think that's something we might have to entertain, just so we don't have another conflict of interest. So,
Mr. Kessel, where does that leave us with our contract with Macoff Kellogg? And I know we extended it, so how are we moving forward with the position?
Our original contract, Commissioner Jennings, was with Macoff Kellogg on a very short-term basis, but we extended that contract to a monthly basis with a 30-day notice to appeal or to decline. So we're okay. Ms. Kripe's with us for as long as we want her, or she wants us.
Any other questions by commissioners for Mr. Kessler or Ms. Kripe? Hearing none, Chair would entertain a motion to adjourn.
So moved.
Second.
A motion, a second. All in favor?
Aye.
Aye.
Meeting's closed.